our guests for the third webinar series that Coram Chambers is doing. We're really grateful for your attendance, and we hope that this will be a really helpful session for you. The way that this webinar is going to work is that Victoria and I, we are the people obviously who are doing this webinar. We're going to be kicking off with a discussion and advice about private and public law contact and the way this should be managed over the forthcoming period. And then we're going to move on to 4 questions which have been sent to us in advance of this session. I think Rakaya has put those questions up, but what we're going to do in any event is read them out to you as we go along. So there are a few things that I would just like to flag up before we get stuck into the meat of the seminar. And the first is that this is a recorded webinar. So if you are feeling uncomfortable with your face being on this session, then what I would advise you to do is to take off the video function. And the second thing I'm going to politely ask you to do, if you don't mind, is to mute your computer, because actually the combined noise can be quite distracting. So as I indicated, this is the third webinar session that we have had. I'm going to hand over to Victoria because actually we are raising money for quite a special appeal at the moment, and we're really glad to be part of this.
Yeah,
and I also think that Victoria is going to be all that.
Thank you, Anarkali. So we're raising money for the National Emergencies Trust Coronavirus Appeal, which is raising funds for local charities and voluntary organisations who are best placed to provide some vital support to people in the communities in the quickest way possible. And so this series of webinars is raising money for that cause. I think Rakaya is going to put the link to our fundraising page in the chat function. If you haven't yet had an opportunity to contribute and you would like to do so, we would encourage you to do that after this webinar. I think so far from the first 2 webinars we've held, we've managed to raise over £300 for that appeal, and we're hoping to continue that over the course of this webinar series. Which brings me to the next point, which is a quick plug for our upcoming talks. We're going to have another talk in the next week or so from our ADR team, which is one of the topics we've actually been asked to cover today. And so if that is something of interest to you after today's talk, watch out for that one coming up in the next week.
Yeah.
On the 27th of April, we have a talk from the protection team on competency assessments. The following Monday, on the 4th of May, we're having a talk from our finance and private client team. And finally, on the 11th of May, there'll be a talk from Anarkali again, and another colleague on parental alienation. So keep an eye on our Twitter, LinkedIn and website for details of those if you'd like to join us. And now I think I'll hand back to Anarkali to give you an update on contact in the private children law sphere.
So what Victoria and I were hoping to do was just give start the session really by giving you some advice about, I think, one of the things that we've been asked about the most since COVID, the lockdown has started, and that's about contact. So I think the way in which you are going to be approaching contact is obviously very different because the circumstances of the country you're in are so unusual, and also they do throw up quite interesting legal issues for us. I'm going to talk a little bit about contact in the private law sphere, and I think the first thing that I really need to note is the President's guidance. So we received that a couple of weeks ago. It was extremely helpful guidance, I thought, insofar as it went. What it did explain was that he expects some adherence to the spirit of the order, if not the letter. Now, I think for people who, well, for us, when we have clients who are querying whether or not they can actually adhere to the letter of the order, and perhaps are looking at this time for as an opportunity, perhaps not to adhere to the order in the way that they might normally feel themselves compelled to do, what I really think you need to be doing is advising them that courts, I think, are going to be scrutinising this period quite carefully when things return to normal. So I think part of the difficulty with the, part of the helpful approach that the President laid out, but part of the difficulty also is that he assumes that both parents, in my view, want to facilitate contact. And as you will understand, that's actually not the reality of the case, certainly not the reality of the cases that I deal with on a daily basis. So what do we do when we have parents who aren't facilitating contact in any meaningful way? And what do we do when we're representing parents who aren't having any meaningful contact with their children? My advice to you is this: I really think you need to be scrutinising why the letter of the order can't be adhered to. So I understand what the President says about the spirit of the order, but actually, if both parents are self-isolating and have been self-isolating for three weeks, 2 weeks, it's very difficult, I think, for a court to be able to follow any argument that a child would not be safe in either of those households. So I really think what you need to do is scrutinise what reasons and the quality of reasons that a resident parent comes up with for not facilitating direct face-to-face contact. And if they're lacking, I'll give you a little bit of advice about that later on. But I think actually, I mean, it may be, of course, that your client has a particularly vulnerable family member, doesn't want to run the risk actually of a child coming into the house and potentially bringing something into it that's putting other more vulnerable members at risk. So, for example, you know, if you have a very elderly parent who you live with, you may not wish to actually put them at risk with a small child running around, even if you know that that child, strictly speaking, should not be carrying coronavirus. In those circumstances, I really think that what you need to be looking at is really good quality and direct contact. And again, I think, go back to the President's guidance. What you should be trying to do is observe the spirit of the order. So really, you should be setting up a regime of contact which to some extent mirrors the contact that you had or that client had before the lockdown went forward. So for example, if you had a non-resident parent who saw their children every Wednesday and had every other weekend overnight, you need to be trying to propose sort of regime that means you have half an hour on a Wednesday by Skype and a couple of days at the weekend by Skype as well, and perhaps some sort of Skype activity. And I think this is what I have found quite interesting about the lockdown. It's the quality of creativity that some parents have applied to this. So for example, I had a case not long ago where a mother who was actually very interested in facilitating contact, she started to play a game with her little girl, and the child was only sort of 2.5, 3. And then what happened was that game was played in front of Skype with Daddy on the other end of the Skype, the computer. And then Daddy started taking over the game. And so the child ended up playing the game with her father through Skype. And the other thing that this mother did, which I thought was really very interesting, was both she and the father had the same books. So she would settle the child down and start reading the book to the child, and then Daddy would start to take over from Skype and start saying things like, "Now turn the page," "What bunny is this? You know, what's he doing here?" And so the child actually started to enjoy activities with the father. And I think that's the sort of creativity that you're going to need to be advising your clients to employ during this time, because I think you know, just having a phone call with a 7-year-old and saying, "What did you do today?" That's not really going to cut it in these times, and actually it's not going to be satisfying. And also it means that parents who don't really want to facilitate contact, you're just letting them off the hook. And I think that's really what you want to avoid the most. Now, I'm going to sort of finish up this advice by saying, I think you need to be kind of really proactive about this. You need to be setting the agenda of contact, particularly if you're for a non-resident parent. And if the resident parent is simply not facilitating, complying, or engaging with indirect contact, I really think you need to be thinking very carefully about advising your client to take this back to court for an immediate and urgent hearing on the matter. So what we know about at the moment is that courts in some ways have never been less busy. So they're not chock-a-block with trials anymore. All their 9-dayers have just left the building, quite literally. And so they've got plenty of time to listen to contact dispute. And I don't really see why they can't listen to my contact dispute. And that's what I would advise you to do. I think you should be making applications. I think enforcement is going to be quite difficult, but I don't see why you shouldn't be making an application to vary according to what you consider to be a sensible contact regime. And you really need to be putting pressure on making sure that this contact is facilitated and it goes ahead. But the relation between the child and the non-resident parent, I think at the moment, is going to be so crucial to be maintained. And obviously we all have a part to play in that, in the way that we advise our clients and put their case. So that's my advice, essentially. Be quite proactive and also be quite litigious. I mean, at the end of the day, that's what we're really here to do. We need to litigate these cases if they need litigating. And I think there's a mistaken belief that we're not going to succeed in any way, shape or form by litigating at the moment. That actually doesn't accord with my experience. I think courts are very interested in this, and they are not minded to allow parents who don't want to facilitate contact to get away with that. So Victoria, I think you have something to say about public law contact, which again is very interesting.
Thank you, Anarkali. So I think I want to look at what local authorities are doing to facilitate contact in the current circumstances, what they perhaps should be doing if they're not doing it already, and what you can do if you're acting for parents who disagree with the proposals the local authority is making. And so we all know that under Section 34, the local authority's got a duty to provide reasonable contacts. Anecdotally, what I'm hearing on the ground is that what that is turning into, there's a really varied approach across the country, I think. Some local authorities are being very proactive. I've heard stories of them providing smartphones to parents that don't have smartphones, providing some SIMs or alternative phones to foster carers that they can facilitate contact safely. And the default in most cases in their area is that contact is by video, whether that's Skype or FaceTime, in all cases where that can be done safely. I think there will of course be some cases where it may not be possible to have video contact safely, but on the whole, those are the minority. And then in contrast to that, there are other local authorities where it seems that the default is telephone contact only. And I've even heard one example of a newborn baby being removed and the mother not being offered any contact at all, on the basis that sort of video or telephone contact for a baby was felt to be meaningless for the baby. And so several weeks have passed without that mother even having sight of her child via a video call. And so there really does seem to be quite a range of approaches on the ground. I haven't heard of any local authorities who are still facilitating direct contact. I think partly the contact centres have closed, and I don't think that's a reality in most areas. In my view, what they should be doing is video contact in all cases where that can be done safely. This is a situation which is going to cause huge anxiety both to the parents and to the children. I mean, children that are separated from their families already have a degree of anxiety about their parents and their welfare. And I think, depending on the children's ages, this situation only adds to that anxiety, and regular contact with their family will help to alleviate that. And I think, bearing in mind, looking at a situation where we've got direct contact's not going to be possible, we really do need to be having video contact in all cases where that is safe. And I think where we have a local authority saying that it's not safe, it can't be done safely, they need to be articulating exactly why that's the case. And if it is because of anxiety of the foster carers not wanting to facilitate that directly, not wanting to be seen by the parents, the authority can explore whether or not it's possible to have a sort of third party to facilitate that video and to try and be a bit more creative. I have heard that there are some contact centres that are sort of providing that sort of third party remote facilitation of contact, perhaps more so in private law cases, but I think that could be utilised in the public law, where a foster carer can get the child on a call and then step away themselves from the camera, and then the third party can facilitate and supervise the contact that's happening between the child and the parent. And so I think, you know, if the local authority is saying it's a safety issue, that needs to be, you need to ask them to articulate that and explain really why that can't be ameliorated. I would also say that, in my view, as a lack of resources, you know, saying that the foster carers or the parents don't have the right technology, again, isn't for me good enough. This is a situation that's going to go on for some time, perhaps, and I think, you know, if other local authorities can provide telephones and SIMs to their foster carers and their parents, then that's something that all local authorities should be looking to try and achieve. Certainly, the courts have said previously that pre-COVID that the contact arrangements need to be driven by the needs of the family and not by the resources of the local authority. And I don't see why that doesn't apply to this situation. And I think in the case that I mentioned at the outset of the baby, when we're talking about very young children, if the local authority is saying, well, you know, for a 6-month-old baby, where is the benefit in video contact? We're not going to facilitate that. You know, we need to remember that whilst it's commonly said contact is for the benefit of the child, these parents also have Article 8 rights, and those need to be respected. In a situation where it's causing no detriment to the baby, but will mean everything to the parent to be able to see their child, to be able to speak to it, or sing to it, or read its stories. You know, just hearing their parents' voice may well have a benefit to that child. And if it's causing no detriment, then again, I don't think that's a good enough reason to be denying parents regular and generous video contact. And so if you are acting for a parent and the arrangements the local authority is putting in place in this time don't, in your view, meet what is required, then I think we should be making applications to court. Under section 34(3), a parent or a guardian or someone with parental responsibility can make an application, and the court will make whatever orders it considers appropriate for contact in that situation. And so, which is why it's important, if there are objections from the local authority, for you to ask those to be articulated. And if you don't think those are reasonable, or you think those can be ameliorated by putting in place other measures, and the local authority is pushing back on that, then make the application and get it before the court. So that should be my advice, I think. Anarkali, do you have anything to add to that?
Well, only that I was litigating not long ago a case where the local authority were refusing to facilitate contact on the basis, as you've indicated already, that the child wouldn't benefit because the child was so young. And I was for a parent, and I'm afraid I wouldn't accept that. My client has a right to see her child, and I can't see why the local authority shouldn't facilitate that. And you know, they're under a duty to do that. And I think if you're quite pushy with them, initially it seemed like this sort of weird slam dunk that I was just going to accept, that you know, because it's a lockdown, my client shouldn't even be able to see her child through video link. And I found that quite a peculiar approach, and naturally did not really go along with it. But also, if you push them and explain, there are Article 8 rights here. You need to explain how it's proportionate for you to facilitate no contact whatsoever. I did find that the quality of their resistance did sort of slip away a little bit. So we did, and actually, I think what was so interesting was that the court themselves actually were very alive to the fact that parents should be having contact indirectly. So the court was saying, because I pitched it really high and said I think she should be having contact 6 times a week, and of course everybody was saying I think twice a week at most. But actually the court was quite sympathetic and said I don't see why it shouldn't be any more than at least 4 times a week. So I think it's really worth pushing those things if you can. Thank you so much for that. And actually what I was going to suggest now is that we move on to the first question, unless you have something else you wanted to say on that, Victoria.
Only say before we move on, we have had a question from Lorna saying, when the COVID Act made a particular exception for child contact, why should indirect video contact be the norm? Can we not seek ways to achieve direct contact for the children to move from their foster home to a local park or somewhere for the exercise hour and see parents in that situation, supervised, be it by a carer or if they're not willing to meet the parents, then another family member. And I think there may well be cases where the risks are low, where it's certainly worth exploring that. I think the difficulty will be with a lack of supervisors, a lack of contact centres, a lack of supervising staff that are willing to come into contact with both foster carers and birth parents out in the community. So I think that may well come down to the level of risk in a particular case and whether or not the foster carers or a social worker feel able to manage those out in the community. But if you have that sort of case, then it's certainly worth exploring. And if you don't think the local authority is being reasonable, then again, make the application and get it before court.
Yes, I agree. I mean, I think that if you're dealing with a case, I think the difficulty really is that with so many care cases, what you're dealing with are parents who are replete with risk. And the only way to manage that risk is supervised contact. And I think that's the difficulty with it. It's not always the case that every parent in a care case presents with kind of, you know, a galaxy of issues, which means that direct contact is not necessarily safe for the child, but that you are more likely to encounter parents in care proceedings where that is the case. And I think managing that is what's so difficult, and that's why I think supervised contact has become so much the norm in these cases.
And we've just now had a follow-up question from Jane saying, what if it's alleged that the child does not want contact, in this case a 5-year-old child? Jane, is that in a private or a public law case?
I mean, I think to some extent, while we're waiting for Jane to come back to us on that, it's irrelevant, because I don't really care what a child of 5 years wants. Their wishes and feelings aren't determinative. And actually a child of 5 really does what that child is told to do by the person who's looking after them. I mean, obviously if that child's been abused or hit, then you do really listen to what they've got to say. But a child, I mean, I would not, so there are 2 points. First of all, their wishes and feelings aren't determinative at that age in any event. But secondly, if it's indirect contact, I think it's perfectly understandable for children to be reluctant to engage in that, because I think indirect contact is actually not an obvious skill that a child has learned. And if you think about it, speaking on the phone or WhatsApping or FaceTime and Skype, these are particular types of interaction that we develop as we grow. They don't come naturally. And I think most people will have experience of children where in person, you really can't shut them up for love or money. But actually when they're on the phone to you and you're asking them how their day is, they're literally monosyllabic. So I think learning how to use technology and communicate with their parents is something that a 5-year-old needs to be taught how to do. It doesn't come naturally, and that's what I mean about, you know, this is such a crucial time for assessing the extent to which foster carers or resident parents are genuinely committed to contact, because they have to teach their children how to do it.
It comes back to your point about the creativity, that if you're just putting a child in front of the screen and asking them just to have a chat, then that's not necessarily going to be the most enticing offer, whereas playing a game together, reading a book together, watching a film together, are ways that you can kind of try and build on that in a more natural
I mean, if you ask a child how their day was, you're normally going to get a word back, but that's not really how conversations with children work. Normally, you are going to have your best conversations with children when you're walking back from school and they just start of their own accord telling you about stuff. And then if you try and get them to repeat that to another adult, they'll sort of say things like, oh, it was really nice, which doesn't really go anywhere. I mean, the fact is you need to be able to work towards creating an environment where children volunteer bits of information. And that's how conversations, or the best conversations with children, take place, really, or with anybody, really. But like I say, that's something that that child needs to be taught how to do to some extent. And I think we need to make that conscious, because at the moment, it's a really easy excuse to just say, oh, you know, little Johnny or Jane just doesn't really like being on the computer. And that I wouldn't expect them to, but that's not the deal. Okay, so let's move on to the first of our questions. So this is practical tips on running alienation cases, and the questioner here has written, so many parents state they're being alienated from their child by their ex-partner. It's really hard to get these cases up and running. Should we be thinking about experts such as psychologists from the start, or should we be following Kafka's lists and build on these? Any tips on drafting witness statements would be appreciated, as it's hard to avoid mudslinging. So I thought this was quite an insightful question in many ways, and actually the difficulty is it's going to take an enormous amount of time to answer it comprehensively. So I would tell you, in the week of the 11th of May, Sophie Hill and I will be doing a much more in-depth talk about running your parental alienation cases. But for the purposes of this webinar, I suppose there are a few things I just want to highlight. So parental alienation is one of those terms which is bandied around increasingly by your client and by litigants in person. And I think distinguishing between a case that is genuinely about alienation and between a case which involves features of alienation, but alienation is not necessarily the dominant dynamic in that case, is actually one of the most difficult things that you will do on the ground. For me, I personally do find the Kafka's checklist quite helpful. I know it's quite controversial. I don't really know why, because I think it's actually, it gets really to the heart of it, which is the lack of proportionate response of a child towards the non-resident parent. And I think really that's such an essential feature of parental alienation cases. I also think when you're looking at these, what you really need to be looking at is the extent to which the child itself has taken on the hostility of the resident parent. So for example, what you'll get a lot of are clients who say to you, I know that the other parent slags me off all the time to my child, it really upsets me, and I know it because my child comes to me and tells me what they're saying. And I think that, I mean, I as a lawyer, that is an element, certainly, of alienation, but the extent to which that now becomes an alienation case really depends on the reaction of that child. So if the child is internalizing that hostility and actually ends up taking on that hostility and parroting it back, and saying things like, I don't want to see this parent or that parent, or I don't like them, or when I was with them, they hit me, or they pulled my pants down, that's when, in my view, this case becomes more of an alienating case rather than just a usual sort of common or garden two parents who just really hate each other and can't put their feelings aside for their children's sake. So I think those are two actually quite helpful guides to help you determine at an early stage, although I would advise actually in cases of this sort that you do get counsel who are experienced in this area to advise as soon as possible, actually, because I think it's very fact specific. The second thing is, I think you need to be looking at these cases to be setting them up like fact find cases. So there's quite a good case from 2018 called Re J, in which Sir Andrew McFarlane deals with a parental alienation case, and he says the pity of the case is that it wasn't litigated properly from the start, because actually the father's concerns about alienation, he made clear right from the beginning, they were never ever grappled with by the court, and by the time the case had come to a final hearing, it was de facto determined because of the quality of the children's resistance, and it had been going on for so long that nothing could be done about it. So I think what you need to be doing, if you think that this case has got significant features of alienation, or it's a dominant dynamic in this case, you need to be looking at creating schedules like you're dealing with a domestic violence case. That's how you need to be treating this. And you need to be trying to get a fact find on this case as soon as possible. And there's case law for that as well. So that's a court approved approach. And I think I mean, I do an enormous amount of parental alienation work, and I know Victoria does as well. One of the pities of these cases is that when you're litigating for the child, it's often too late, too much time has passed, and there haven't been factual determinations, and you need to do that. And it's the factual determinations that will feed into whether or not actually a Part 25 for a psychologist or a psychiatrist is appropriate then. So the last part of the question was really about the extent to which mudslinging can be avoided in those statements. And I think that's a really good practical point, because there is almost nothing in my experience that turns a judge off more than hearing about two parents who just don't like each other. It's really boring, if nothing else. And I think what I would do that so many parents' witness statements don't involve is actually just bringing it back to the distress of the child. And that's what I think, in my experience, there's a wholesale failure to do that. And it means that actually your case is going to be much less compelling as a result. So for example, if we have two examples of witness statements dealing with exactly the same point. So if we were to say, if this were from a resident parent, and she says, you know, when Jamie's dropped off, Clive comes to my car and calls me a fat bitch in front of him. It upsets me so much that I'm crying all the way home, and then I get a massive headache and need to go to bed early. So that is actually quite uncompelling, frankly speaking. But if she were to write this, he calls me a fat bitch in front of Jamie, and actually Jamie gets so upset and asks me all the way home, why is Daddy so mean to you, Mummy? It upsets me. I can't understand it. That's quite a compelling statement from a judge's point of view, because what it does is it recognises the emotional abuse, which is actually at the heart of these cases. And these cases are about emotional abuse. So I would keep bringing it back to the child's response and how the child is unable to manage this sort of hostility. Victoria, is there anything that you feel that I've missed about this kind of whistle-stop tour?
Just a couple of other things to add to the statement. So I think one is, if this is a situation where the non-resident parent did have previously a good relationship with that child, you know, focus on what this child is now missing out on, not only the relationship with you, but also their wider family, you know, significant events that child may have missed if they've got a good relationship previously with their aunt, their cousins, and that has now stopped. Again, that's a really big indicator that this is, it might be a case of alienation if previous positive relationships have now come to an end, and the focus you're putting on is what that child is missing out on as a result of the resident parent's behaviour. Also try and identify some positive steps your client has taken to try and improve the situation, so whether they've attended the SPIT, whether they've done a parenting course, whether they try and engage with the child's school. Those are focus on the positive steps your client's doing to try and improve things, and ways in which your client may endeavour to promote the other parent. So do they help the child write Mother's Day cards and send birthday cards to the resident parent? You know, examples where they've spoken positively about the other parent to the child, because again, that will contrast with what the other parent is not doing, and will lead the judge to question, well, that's what this parent is doing to try and promote the parental relationship. What is the other parent doing? And so I think in slightly more sort of constructive ways will highlight some of the deficits of the resident parents.
Thank you. I think those are really good points. And like I said, I think before, when I was talking about private law cases and contact, you really need to be quite proactive about how you approach contact in those ways, and actively promoting the other parent, and that goes for both parents. And ultimately, if you are looking at a transfer of residence, or if that's your client's case, the one thing that for me is really determinative in these cases is whether the non-resident parent can promote both parents. That, for me, is the matter on which a transfer of residence will turn. And if you have a history of a parent, a non-resident parent, who has been able to promote the resident parent in a positive, healthy and safe way, despite everything that's been going on, you are going to be so much more persuasive when you put that case to the court. Right, so the next question that we have is it safe for parenting assessments to be carried out during this period? Victoria?
So I think there's no sort of easy answer. I think that will very much depend on the families that are involved. So I think undoubtedly there may be some cases where parenting assessments can either in part or in whole be undertaken in these times. So if you have a situation where the issue is a long-standing issue, where there is already perhaps good evidence for that, so for example if it's a drugs case and there's been long-standing substance abuse problems, pre-COVID, you've already got your hair strand test, you've already got a history of poor engagement with services, and what the parenting assessment is doing is looking at insight, looking at motivation to change. That may be an assessment that you can do largely or wholly remotely. Whereas in contrast, there will be cases and families where any sort of assessment in this situation is not going to be appropriate. So if you have a client or a parent who has a learning disability or a learning difficulty, or perhaps where an interpreter is required, it's much less likely to be a fair process if that's done purely remotely, and will undoubtedly be challenged on that basis. And I think, particularly for parents with learning disabilities, it's very hard to imagine how that can be done fairly. I think we also need to consider, sort of for all families, one, the technology capabilities within the home. Do the parents have Wi-Fi? Do they have a laptop? Because again, asking them to engage in sort of long interview sessions if all they have is a telephone, that's going to make it much more difficult. Are the children at home still? If the children are at home with the parents, will the parents have the time and the space and the ability to focus on engaging in assessment sessions if the children are at home, and is there a risk that children are going to be exposed to those conversations? If domestic violence is an issue, is the parent still living with the alleged abuser? Because again, discussing that might not be safe in that environment. If we've got a parent who might be particularly vulnerable because of mental health issues or history of abuse, I think local firms do need to think about, is it right to ask them to talk about and open up about those issues where they might not have appropriate support afterwards? Are we going to be triggering them when they don't have access to their usual therapists or to their support workers? And think about how that's going to work. And I think what we do need to be asking is local authorities to produce very clear parenting assessment proposals. They need to be setting out what work can be done remotely and what work can't be done remotely. So I've heard there's a lot of cases where independent social workers, for example, are saying that they can't complete assessments because they can't observe contact, they can't observe the dynamics in a relationship.
Yeah, I don't know. I would have got in the shower if there's still going to be contact.
That's right, and I don't think we should necessarily be abandoning those because of this environment. But nor does it mean that no work can be done. It may be that some of the initial interviewing sessions can take place, some of the sort of history discussions about sort of insight and so on can be done remotely. But that assessment will have to be completed after this lockdown has eased, so that those observations and time spent with the family can be undertaken. And so, at least by doing some of the work up front, we're ameliorating the amount of delay we're going to have afterwards. So I think, in those situations, it may be that you can have an interim report on the basis of the work done during the lockdown that's done remotely. And then a final report scheduled for after the lockdown is eased, so that work can then be completed. So I think there is no easy answer, but I think those are some of the issues to consider in your particular circumstances to see whether or not it's appropriate at all to start an assessment, and if so, what elements of that can be done.
I completely agree, and I think plans for assessments are going to be quite interesting, and they might be one of the features of the lockdown that actually continues, because they're really quite helpful in helping us understand how assessments work. Because actually, I mean, it's not that we don't understand them when we read the assessments, but it's actually quite interesting to see what factors, as the assessor is going through the assessment, are really determinative for that particular assessor. but I think that it's going to be so fact dependent at the moment, and it really depends on the facts of that particular case. And Victoria's absolutely right. If you've got a case with a parent who's had issues for a really significant period of time, is 2 observations of contact really going to make a significant difference to the overall recommendation that an ISW or an assessor is going to be making for that child? And realistically speaking, I don't think so. So that brings us to the third question, which is, how do I sell private arbitration to my client? Well, I can't imagine better circumstances to be selling private arbitration to your client than current circumstances. The reason being that, as we all know, we're in lockdown. There's much less access to court than normal, but it seems to me that actually this is really a time where solicitors more than ever ought to be considering private arbitration. First of all, you get to choose your own arbitrator. Second, it's so much quicker. Third, of course, it just means it's very empowering for clients, I think, to have some sense of determining what it is that needs decisions made. And I think it's also very cost effective, because it means that if you've got parents who are able to identify issues which are really affecting the quality of their relationship and the parenting they're able to offer their children, and it means that they can actually have it dealt with within, for example, a month, as opposed to a long drawn out process in court, which could take up to 6 months when you factor all 3 hearings in. I'm sure you're all aware of this, but domestic violence and parenting safeguard, if there are safety concerns, that's not suitable for arbitration. But actually, I think now more than ever is the time for you to start exploring arbitration with private law clients, and select a good arbitrator. I know in Chambers that we have a very good team of arbitrators, and Coram is really famous for producing judges, particularly good ones. Actually, I think really what you're looking for, and what I would advise you look for, is an arbitrator who has judicial experience. And so many of the arbitrators in Chambers, for example, Jane Drew, Mike Horton, and so on, have got, and like Jackie Marks, for example, these are all people who have judicial posts and have the training as well. Victoria, is there anything that I've missed about this, do you think?
No, only to say that from a personal perspective, I was involved once in a finance arbitration case, and what was really clear to me was just how much more time the clients are afforded in that private arbitration setting compared with in court, where you're one of a number in a list that day and the judge has got limited time for you. In the private one, the clients had all day. Their issues that may in a court sometimes be considered trivial by a judge who's dealing with lots of sort of important safeguarding issues on a daily basis, were given the time that those clients felt they deserved. And I think, they felt that, their issues had been given the proper attention, that they'd had the time to consider things properly, and it hadn't felt rushed in the way that, often it can do in a court setting. And so, that would be another sort of, that was my perspective on it, that not only does it save you a lot of time waiting for a final hearing in the courts, you're also given much more time on the day of your hearing or the day of your arbitration for your issues to be sort of fully explored. Yeah,
and it will save them money as well. I just can't see how it won't. Right, the final question, which is, this is a really great question actually. When you act for teenagers in care proceedings where their competence is continually being assessed, to do this without meeting them in person is difficult, even if you meet them face to face. Do you consider it's acceptable to say to the court that in some borderline cases, a final determination of competence should wait until a face-to-face meeting can be held? Victoria, what are your thoughts?
Shortly, yes, I do. I mean, I think there will be cases where, if it's a teenager you've worked with for some time, or you've been working with them prior to the lockdown, Or some children where it's very clear and obvious to you just from a phone call or a video call that that child is competent, and you feel confident in making that determination, then do so. I think the fact that you haven't been able to meet them in person shouldn't stop you if you have that confidence from the conversations you've had. But of course, there will undoubtedly be more borderline cases where you don't have that confidence to make that determination, but certainly you are, there's enough there for you to think that child may well be competent. And I think in those situations, we should be saying to the court, you know, we shouldn't be proceeding here with a final hearing in a case where, you know, this child disagrees with the guardian's recommendations and may well be competent, and I don't feel like I've been able to properly assess that, because the consequences are you go ahead with the final hearing and make a final determination where a child who later turns out to have been competent wasn't represented and their point of view wasn't put forward. So I think, you know, in those cases we should absolutely be saying this should wait, because the consequences, you know, delay is not as bad as making decisions where that child doesn't have representation. What's your view, Anarkali?
I think it's really interesting because, well, for a start, competence fluctuates. And that's one of the difficult things that people who are children's solicitors have to kind of get to grips with, but it's more difficult and complicated further, I think, by the lockdown. But secondly, I do think that really what we're dealing with, the heart of this question is an Article 6 point. And I think you touched on that, Victoria. That, I mean, it certainly is the case that even if children don't agree with guardians, their views are put to the court. But it's not the same as having your own representative. And we all know that, because otherwise what's the point of parents having their own representative, or anybody apart from the local authority ever being represented for that point, for that matter? You know, it's a really qualitative difference. And if that child ought to be represented separately, then you just need, you know, that needs the proper process for engaging with that needs to take place. Article 6 rights are absolute rights. They're not qualified rights, the way that Article 8 rights are. And I think I would be very surprised, actually, though, if a court wasn't sympathetic to a solicitor who had approached this very thoughtfully and was being quite cautious. I would be very, very surprised. I'm not saying it would never happen, but I would be very surprised, actually, if a court weren't quite sympathetic and prepared to adjourn on that basis. So I think I think we've got 10 minutes to go or so, and we've had a few questions, actually. Which
a number of questions, yeah.
Yeah, I think I've been keeping an eye on them, and they're really great questions. Shaylee had a really good one, and she said, is it sensible to advise your client who has contacted the child during the pandemic that they can offer the parent catch-up time post-pandemic, even if it could open up a can of worms, and that other parent pushes for more contact in the long term? Well, I think that's what's so interesting about this, because what it's doing is arguably setting new precedents in a case where you, as a litigator or as an advisor, have been really working very hard to manage contact, because you don't want it to set precedents for the future. And Shaylee, it's really difficult to kind of generalise without kind of reading specific cases and advising specifically. But my feeling is that you ought to be offering something in the nature of catch-up time, but I would not be offering any more than you would typically offer at a holiday, for example. So what you can't do is offer a whole block of catch-up time for the whole lockdown period, because that will just run into months and it will set a new norm. But if you are a resident parent and you have got concerns about the non-resident parent's ability to manage the child for, say, more than a weekend or more than 5 days or 7 days at a time, my advice would be that you give them several periods of weekends in a row, or weeks, if you've got if we've got the holiday time for you to do that, rather than you just run them all in one go. Because I think if you run them all in one go, you are establishing a new norm, and also you're letting go of any safeguarding concerns that have lain at the heart of any of your case to that point. So I think it's really about a balance. But yes, you do need to be promoting that. I think I've made that very clear, but it's about balancing it with the concerns that the parent that you're representing already has. Victoria, while I've been saying this, has anything occurred to you about that you can help, make my answer better?
No, I don't think so, Natalie. I think I agree. I think it will very much depend on the situation. It's also difficult at this time to be, if you are the resident parent and for appropriate reasons you've decided that direct contact can't take place at the moment, it's still very difficult to offer anything specific by way of make-up time, because we just don't know when this is going to end. Will the children be going back to school, or are they going to be off until September? And I think, make it very clear that there will be an offer of some sort of make-up time to try and balance the fact that it's so limited at the moment. But I think you do want to be very careful about setting up a new routine, because the other parent will then argue that if that's been going on for some months, then that's now set up a precedent, and that's a routine the child's got into and is comfortable with, and why shouldn't that continue? So I think it does need to be handled quite carefully, but obviously will depend on the circumstances of each individual case. So I think in terms of other questions, we've heard back from James saying it was a public law case where this 5-year-old is apparently being said that they don't want to have contacts. I think that it's very difficult without knowing the details of that case, but I think you need to be asking the local authority to explain why it is that child is saying that they don't want contact, what work is being done with that child around that. Was there contact taking place prior to the lockdown and that's now a sudden change, in which case that needs some exploration. Or is this a case where contact hasn't been taking place for some time? So I think you need a lot more information from the local authority about why they're saying that and what they've done or what they're trying to do about it. But I think without knowing a bit more detail about that, it's difficult to be more specific, but that's something perhaps we can discuss separately after the webinar. And Anarkali, do you have any thoughts on that?
I just think that if a child, so this is one of the weird things about public and private law children. Contact should, in my view, be approached in a reasonably consistent manner by the courts, but it often isn't in practice. And I think one of the weird things is that in public law proceedings, if children don't want to have contact with their parents, that's explored quite quickly, actually, with an attempt to resolve it typically. I mean, obviously it's practice dependent. If the child has got really good reasons and that parent's been abusive, then that's really the end of that exploration. But actually, if there's no obvious reason, then the local authority will really, in my experience, pull out all the stops to encourage that child to see the parent. And I can't see why that wouldn't continue to be the case at the moment. I mean, social workers should be checking in with foster carers. They should be having, I would have thought, indirect contact, I mean, by way of Skype or phone call with the children whose cases they're running anyway. And I can't see why they wouldn't be exploring with those children, why you don't want to see your auntie, why you don't want to see your brother, why don't you want to see your dad, in the usual way that they would do face to face. I don't really understand. It's not clear to me from that question why a lockdown would make any difference to the responsibilities of the local authority or a social worker in just because there is a lockdown. All these matters need exploring for the children's, it's part of the children's best interests. And I think particularly if you're dealing with a young child, that needs to be explored robustly as quickly as possible, because they are the most, of all the, young children are kind of the most malleable in some ways. I mean, obviously not in the short term because they have massive tantrums, but in the, in the kind, like their resistance tends to be less enduring than when, for example, they're 14 or 15 and they're much more difficult to persuade to do something they don't want to do. If you keep reintroducing something to a 5-year-old or a 6-year-old, like broccoli, eventually the theory is that they will eat it. Whereas a 14-year-old, you can just, you know, crack on with your broccoli. That's just never going to happen.
Well, I think I'd only add, Anarkali, that, you know, even though we're in lockdown, if the local authority are effectively suspending all contact with a 5-year-old, you know, they have a duty to promote reasonable contact, and they can only suspend it for a period of 7 days without bringing it before the court for authorisation under Section 34. And if they haven't done that, then you should be pushing them to do that. I think if, you know, unless your client accepts that no contact is what is reasonable, which doesn't sound like they do, then the local authority aren't, in your view, providing reasonable contact, and they should be making that application to court themselves. So I would be pushing them to do that, I think, Jane.
Yeah, are there any other questions? I think my chat function is a little bit behind everybody else's, actually.
So I think we did have a question from CL asking if, in a public law case, if the only contact is by phone or video link and there's no face-to-face contact, can a parenting assessment be completed, and if so, can it be fair? And I think hopefully we've covered that. That was one of the sort of questions that we had for this seminar. So hopefully we've covered that. And I think otherwise that's all the questions we've had so far.
We did have one question early on from Lorna. I'm not sure if that one was addressed. When the COVID Act made a particular exception for child contact, why would indirect video contact be the norm? Was that answered by you, Anarkali?
Yeah, I think we were trying to incorporate it actually as we went along. I mean, I suppose going back to what CL was saying, can it be completed? I think really the issue for the courts is going to be at final hearing, and it's the extent to which these assessments are vulnerable to challenge. So assessments always, or typically, carry some vulnerability to challenge. That's why we have the assessors there and we cross-examine them. That's the whole point of it. But obviously in these times, they're going to be more vulnerable to a successful challenge. And, you know, it does cut both ways. The simple fact is these assessments are going to have to be carried out. We don't know when the lockdown is going to finish. It could finish in 3 weeks' time or 2 weeks' time, or it could finish in 4 months' time. But, you know, the 26 weeks is still going to be 26 weeks, and something has to be done to manage some of the cases, or those cases that can be managed in the interim. So it's not, I think what you need, if you're representing a parent and you do not think the assessment that is being carried out is fair, what I advise you to do is jump up and down about it, write to everyone, you know, put it in the client's witness statement at the end, setting out what it is that you don't think is fair. And ideally, what you will have in your case is a statement that says, I was really unfairly assessed, I was really stressed, I was suffering from depression because I was locked down. I was also in a one-bedroom flat with an abusive partner and 3 kids, all of whom have got high levels of autism. I don't think this was a fair assessment. Since lockdown, I've been brilliant. You know, my kids are thriving, my nasty ex is kind of pushed off to somebody else, and I'm having a great life. That was not a fair assessment, and it's invalid. And I think the court will find it hard to resist that sort of case. I mean, the tragedy of public law proceedings is that that almost never happens. That's not to say you shouldn't be setting it up to happen that way.
Thank you, Anarkali. I think it comes back to some of the points I was making earlier. You know, if you're for a parent, you've got to be thinking, well, do they have the technology? Are there children at home? Is the abusive partner at home? Are they particularly vulnerable because of mental health or domestic violence or a history of abuse? Are they being asked to sort of talk about things that are going to cause them to become quite upset when they haven't got appropriate support in place? And, you know, we have to acknowledge that this situation, this lockdown situation, is putting everybody under an awful lot more pressure and anxiety than normal. And if you already have a vulnerable parent, you know, is their performance and assessment during this time going to be a fair reflection? And if you set all of that out for the court and say, you know, I don't think that an assessment should be started in these circumstances, the court may agree with you, and if not, you've at least sort of set up your points for cross-examination later on.
This goes to a completely different point, and it's something I forgot to mention in an earlier answer, actually. It's to do with arbitration just before we leave. Shiva Ancliffe and Sarah Branson, who I'm sure you will all know them because their fame precedes them, because they're such wonderful barristers. They are going to be doing a talk specifically on arbitration. I know they're recording it this week, so it should go up online early next week. I would really encourage you actually to download that and just have a listen to it. It will really help you to understand more of the dynamic behind arbitration and why, particularly in these times, it seems to me that arbitration is a really, really good option for your client, something to consider.
And then just before we finish, I think Wakira has just put up the link to our Twitter feed in the chat, and remind everyone that the next live webinar will be next Monday, 27th of April, which I think is the one on the Court of Protection. So thank you everybody for joining us today. I hope you found this helpful. And if you've got any questions that occur to you afterwards, then do feel free to get in touch.
Thank you so much.
Wonderful.